Shalom, me homies. It's Alexandria here again with Formidable Felons, and we are going to be talking about the Lowell investigation again. This is going to be video part 4. I know, I'm sorry it's so long, but it's a 36-page investigation, and we're going to get started on page 21. If you haven't already, please like and subscribe, and please comment down below if you have anything to talk about so far in any of these videos. I would love to have the conversation. We are going to get started immediately. We'll hop right in to B, the subsection of Lowell and the OIG procedures and practices discourage prisoners from making reports of sexual abuse. So this is the second subsection. So during the department's on-site visits to Lowell, we received information that supervisory staff had threatened prisoners against cooperating with our investigation, and in one case retaliated against a prisoner for providing us with information. During our August 18 tour, we learned that a sergeant who was the subject of a long list of PREA-related allegations had warned prisoners in Dormitory A not to speak with department attorneys and investigators visiting Lowell. Specifically, several prisoners reported that the sergeant warned the prisoners to be careful what you say because you may end up under investigation. And that is common. I've seen that personally when they came through. I think the Miami Herald was doing a report on the cleanliness of the dorms, and our Victor dorm got featured in it, but we were threatened with PT, other dorm physical training for the youth camp. Other dorms were threatened as well with violence and investigations in order to make sure that they don't tell anyone about what's been going on here, even though it wasn't the subject of that specific investigation that they were doing. So in this case, the warden took the unusual measure of writing a letter to the sergeant indicating that his permanent reassignment to a different FDOC facility was in the best interest of Lowell Correctional Institution. The sergeant voluntarily resigned from FDOC in April 2019. There's one example of them doing a method of taking the right steps. So during our November 2019 tour, a prisoner approached the department's team and stated that a sergeant, who also was the subject of several PREA-related allegations over a number of years, was repeatedly sexually harassing her, but she was afraid to report it because she was going to be getting a visit from her son and did not want that to be taken away. The team reported this to the facility leadership. The next day, we learned that the reporting prisoner had been placed in administrative confinement. The prisoner's mother had called the shift supervisor that night, stating she feared for her daughter's life because the sergeant made threats against her daughter when he found out her daughter talked to department personnel. And I did mention this in my first video about people trying to save their visitations and trying to save their game time. So that's why they don't put themselves first. And they don't tell. And it's heartbreaking to hear that they have to go through this just so that they can have basic rights of seeing their family. The same sergeant was reported by several prisoners to have said to prisoners during the morning count that you can keep telling DOJ your lies. It doesn't matter how much trouble I get in. I can retire and lay it home. The team relayed this information to the warden, who then released the prisoner from administrative confinement and transferred the sergeant to a different FDOC facility. Again, a step in the right direction, but these are the type of people that we hire all the time. And the minimal amount of training that police officers have to go through I think it's like 600 to 700 hours. I have to go through 1,200 hours in order for me to cut someone's hair for my cosmetology degree that I attempted to get in prison. There's no reason that it should be less than that. And I have to look up the amount of training that correctional officers get. But you see that they're in a position that they can use the fact that they can go home to their advantage. And that is just so demeaning, and it just diminishes a person while they're there to use such a low blow. But it's constantly, they do it all the time. So the side notes in that, because Lowell does not offer meaningful alternatives to administrative confinement, prisoners are generally left with the choice of returning to the housing unit where the alleged staff perpetrator may be stationed, or agree to be placed in administrative confinement. That's the truth. OIG staff informed us that the facility sometimes places victims in administrative confinement without such an order being issued by OIG, and that facility staff nevertheless will state in their written justification of the placement per OIG. So it doesn't make sense, but they still just lie on the paperwork. The amount of paperwork they have to go through and the amount of supervision that is lacking in these dorms makes it easy for them to get away with these types of atrocities, and being able to get away with just minimalizing it on paper. So while the department's team was able to speak with a number of prisoners while on site, dozens of others declined to be interviewed, expressing fear of being seen cooperating with our investigators. And many of the prisoners with whom we spoke similarly indicated that they were fearful that they would be retaliated against. They worry about gangs in prison, but they don't worry about officer retaliation. Subsection 3. Lowell's inadequate system for investigating reports of sexual abuse subjects prisoners to substantial risk of harm. So despite an investigations policy that is adequate on paper, Lowell fails to meaningfully investigate allegations of sexual abuse. The inadequacies identified include closing cases without conducting appropriate investigation of available evidence, closing cases upon the accused staff's termination or resignation, delays in reviewing and investigating allegations, and inaccuracies in documenting and tracking employee terminations and dismissals. Subsection A in that is that investigations are closed, suspended, or disposed of with minimal disciplinary action after an adequate investigation of available evidence. Many sexual abuse allegations are closed prematurely based on OIG's determination that allegations are unfounded after taking only preliminary investigative steps. Of the 161 sexual misconduct cases we reviewed, more than half were closed as unfounded, 78 at the pre-investigation complaint review stage, and 6 after being opened as criminal investigations. All but a handful of the unfounded cases reviewed contain conclusory findings based on insufficient fact-finding, such as failing to interview the alleged perpetrator and potential witnesses. Many contain conclusory assertions that no surveillance footage was available to review, or no additional witnesses could be identified without explanation as to what efforts were made to identify such evidence. Many of the cases that OIG summarily looked at as unfounded were based on third-party and anonymous complaints and grievances, where the victim denied allegations when first questioned. Although an uncooperative victim may present challenges to a criminal investigation, it is essential to follow through with an administrative investigation in these circumstances. Adequately investigating all allegations helps to protect against potential sexual abuse of a vulnerable population who may understandably be reluctant to report against those who have authority over them. Prisoners may also fear discipline if they admit, for example, to exchanging sex for contraband or other allegations that the prisoner broke in prison rules. Third-party or anonymous complaints and grievances may be the first indication of a problem where the victim herself is too fearful to come forward. In practice, however, a full investigation does not occur. An OIG inspector acknowledged in an interview with the department that inspectors often close cases as unfounded after reviewing only the alleged victim. This blunt assessment was consistent with the individual cases we reviewed. For example, in 2018, an anonymous note reported that a prisoner was having sex with a corrections sergeant in exchange for cigarettes. When she was interviewed, the prisoner admitted that she had sold cigarettes to other prisoners, but denied knowing where the cigarettes came from and denied having sexual contact with the sergeant. The case was closed as unfounded at the complaint review stage. Despite the prisoner's dubious statements regarding the source of the cigarettes, no further interviews were conducted, and the prisoner's admission that she was selling contraband apparently was not investigated further. The investigation documents indicate no discipline of the prisoner for the contraband violation, although the complaint review report indicates that the sergeant disciplined her for tattooing. Although the anonymous report contained details about the date, time, and location of an alleged private encounter between the prisoner and the officer in an AC room, the inspector does not explain whether any surveillance video was sought or reviewed, and it's most likely that it wasn't, because these AC rooms are on the side of the dorm. They are just where the air conditioning's set up, and where usually they keep extra supplies that they don't like to keep in the dorm. And it is out of sight. The cameras can't see that specific level, so it's easy to see how that could be a specific area where people are taken advantage of. And in April 2019, an OIG closed a complaint as unfounded, although the inspector interviewed only one alleged victim. Specifically, a third-party grievance filed in November 2018 alleged that a prisoner was involved sexually with a corrections officer, and separately with 2 other prisoners, and one of whom was a youthful offender. An inspector reviewed the prisoner victim in April 2019, and she denied the allegations and claimed never to have witnessed any staff sexual abuse of any kind at Lowell. The inspector closed the case as unfounded without interviewing the alleged perpetrator, who was named in the complaint. The inspector noted that no dates or times were given to permit review of surveillance video, although the inspector does not explain if any attempt was made to identify relevant dates, times, and locations based on the allegations made. The sum note for that is saying the grievance alleged that the prisoner was having sex with a YO, youthful offender, during her work shifts in the bathroom, but there was no attempt to identify any youthful inmates who worked the same shift as the alleged victim. I think they meant to say any, it's complicated in how they said that. Or to review surveillance video footage from the alleged victim's work shift. OIG had an extra burden to pursue these allegations to the furthest extent possible because, in addition to sexual abuse of inmates by staff, they potentially involved sexual abuse of a minor by an adult prisoner. And the way that the work shifts happen is if you have, like, culinary or if you work cosmetology, then you are considered working, even though you don't get paid at all. You're able to build up hours towards a certification, but you do not get paid. But they do consider that work. So it would have been in one of those bathrooms in the culinary or in the cosmetology room over there. So although allegations of sexual misconduct between prisoners are outside the scope of the department's investigation, the apparent failure to investigate allegations of sexual abuse of a youthful inmate is consistent with other problems identified in the department's investigation, in particular severe staffing problems resulting in inadequate supervision of prisoners. Under Florida statute, any person who has reasonable cause to suspect that a child is abused by a person responsible for the child's welfare is a mandatory reporter of the abuse to the Florida Department of Children and Families. Statute 39.201 defines a child as any unmarried person under the age of 18 who has not been emancipated by order of the court. And Statute 3901 with the PREA standard, if the alleged victim is under the age of 18, the agency shall report the allegation to the designated state or local services agency under applicable mandatory reporting laws. In Statute 1, there is no evidence that anyone at FDOC reviewed this matter to determine the age of the youthful inmate mentioned in the grievance and if a referral should have been made. So in short, the inspector closed the case as unfounded, without taking adequate investigative steps. The risk of harm from these inadequate reviews and conclusory findings is not theoretical. The risk of harm is apparent in several cases of Lowell officers who remained in their positions for years despite serious allegations that were inadequately investigated. Some of these officers later were criminally charged, terminated, or investigated again for sexual assault and other grave abuse. For example, a Lowell sergeant who remains under investigation based on credible and corroborated allegations that he forcibly anally raped a prisoner in March 2018 was previously accused of other sexual misconduct cases and that OIG closed as unfounded without adequate investigation. In 2017, OIG closed as unfounded a case against the same sergeant in which two prisoners reported that the sergeant had sexual intercourse with and received oral sex from a third prisoner. The complaints reported specific dates and other details. OIG closed the case as unfounded after the alleged victim denied the allegations. OIG did not interview the sergeant, the complainants, or other available witnesses. A Lowell sergeant who was arrested in February 2017 on charges of having sexual intercourse with a prisoner had been the subject of numerous allegations for years, some of which had been closed by OIG as unfounded despite being inadequately investigated. For example, in January 2016, a prisoner accused the sergeant of receiving oral sex from another prisoner in the bathroom of a Lowell dormitory. The sergeant denied the allegations in a written statement, and the alleged victim claimed in a written statement that she had been joking when she told another prisoner that she had performed oral sex on the sergeant. OIG closed the case as unfounded without conducting any in-person interviews and without reviewing any surveillance footage. In other cases, OIG effectively ends investigations by indefinitely suspending them, including cases involving serious sexual abuse allegations. An OIG inspector supervisor told our expert that OIG sometimes suspends cases that cannot proceed unless new information becomes available. In practice, however, it appears that some suspended cases were not adequately investigated. For example, in March 2019, a prisoner alleged that she had been sexually abused by a Lowell psychiatrist during medical appointments over a period of 6 months. The prisoner alleged that she performed oral sex on the doctor and that he digitally penetrated her and touched and sucked her breasts. The prisoner also alleged that the doctor gave her candy, chips, makeup, and cough drops. The prisoner and the doctor were the only people interviewed. The prisoner maintained her allegations. The doctor admitted he had given the prisoner a cough drop, but denied everything else. No further investigation was conducted, and the case was suspended. OIG did not make any determinations as to whether medical call-out logs corroborated with the prisoner's accounts, whether the prisoner had an unusually high number of appointments with the doctor, or whether the prisoner was able to make appointments more easily than other patients. No other medical staff were interviewed to inquire about the doctor's behavior. The doctor's office was not searched. The report details no efforts to identify other potential victims, such as other patients who saw the doctor around the same time, or any corroborating witnesses. The medical call-out, by the way, is at the beginning of the morning. They will tell you if you have an appointment, which is a call-out over to medical. It could be for psychiatry. It could be for a sick call that you have put in to request to be seen. It could be a variety of things. So OIG has also closed cases or stopped investigating sexual abuse allegations without making investigative findings upon employee's dismissal or resignation. Separation of a staff member under investigation does not alleviate FDOC's responsibility to investigate allegations of sexual abuse. A number of staff who allegedly sexually abused prisoners have been dismissed or resigned while under investigation instead of being terminated for cause based on investigative findings. In some of these instances, OIG terminated its investigation or failed to make progress investigating what may have been criminal misconduct. According to FDOC data, 2 officers in 2017 and 1 in 2018 resigned or retired while being investigated. In 2017 and 2018, 5 more were involuntarily terminated for violating agency policy. 1 resigned in lieu of separation for cause, and several more voluntarily separated for unspecified reasons other than misconduct. Among officers whose separations were voluntary or otherwise did not officially indicate misconduct, the department identified several who previously had been accused of sexual abuse in investigations that ended inconclusively. The department also identified additional examples of investigations stalling or closing without findings due to staff resignations. For example, several officers and other staff were involuntarily dismissed for excessive absence or failure to report. The department's separate review of individual cases has identified at least 1 case where an officer was terminated for unexcused absences following investigation for sexual abuse allegations. By allowing sexual predators to resign quietly or terminating them for ambiguous policy violations, instead of making a finding of sexual misconduct and terminating them for that reason, FDOC fails to deter criminal behavior and sends a message to other officers that punishing sexual misconduct is not a priority. And under exploring or ignoring potential available evidence in sexual abuse cases, whether ultimately making an improper, unfounded determination, leaving a case open but suspended for years, or abruptly closing a case by dismissal or resignation without completing the investigative process, OIG fails to provide accountability and direction to the facility administration to implement monitoring for retaliation and corrective action to prevent future sexual abuse. And that's also inside of the dorm, and if they leave, if they do resign voluntarily or involuntarily, and they're not held accountable, there's nothing to keep them from practicing what they're doing on ladies outside that aren't in the context of the jail. So making investigative findings can trigger important remedial actions to prevent future incidents of sexual abuse and harassment in confinement settings. These specific determinations drive requirements for notice to the victim about the results of the investigation, notice to prospective employers if an allegation against a staff member was substantiated or if he or she resigned during a pending investigation of sexual abuse, consideration of both substantiated and unsubstantiated incidents in the facility's staffing plan, retaliation monitoring, and the sexual abuse incident review process. Lowell's insufficient investigative findings also hinder the facility from taking steps to protect vulnerable prisoners by taking appropriate remedial actions to prevent future sexual abuse. Similarly, harmful are cases where serious misconduct was identified, but trivial discipline, if any, was imposed. For example, in 2017, a Lowell corrections officer was investigated based on allegations that she was having an inappropriate relationship with a prisoner. OIG found that the officer failed to maintain a professional relationship with the prisoner and failed to report receiving personal phone calls from the prisoner's family members. Among other allegations, Witnesses reported that the officer had begun a relationship with this prisoner when the prisoner previously was a youthful inmate at Lowell. Despite these substantiated findings, the officer was disciplined with only a 48-hour suspension. OIG subsequently opened another investigation in 2018 into allegations that the same officer was sexually abusing another prisoner, including allegations that she engaged in oral sex with the prisoner numerous times and gave the prisoner gifts. The officer later was dismissed for failure to report to work for almost 2 months while under the investigation. So they just end up not showing up to work anymore so they could get fired for that instead of being held accountable for what they actually do. In 2016, a corrections sergeant told a prisoner twice to eat a dick. Another officer reported the inappropriate language and also that the sergeant, after peeping around corners to ensure he was unobserved, entered a restroom area that the prisoner had entered and that the two were alone together in the restroom area for several minutes. The officer also reported that the sergeant and the prisoner were acting overly familiar with each other in a common area. Despite the officer's detailed contemporaneous report, OIG subsequently found insufficient evidence to support a finding of sexual misconduct based on review. 3 months later, of surveillance video, because the video did not show the sergeant and the prisoner engaging in sex acts or going into a private area together, the sergeant admitted he had made the crude comments and was disciplined with a 12-hour suspension. This individual remains a sergeant at Lowell, and his name appears repeatedly in prisoner sexual misconduct complaints, including allegations that he engaged in sex acts with prisoners in exchange for contraband and that he verbally abused or sexually propositioned prisoners. Failing to impose discipline commensurate with misconduct allows potential abusers to stay in contact with and supervise vulnerable prisoners and may embolden some staff to engage in abuse while discouraging others from reporting misconduct. And let me just say there too that as a prisoner, if you are found alone with somebody in like the bathroom at the same time, there's only supposed to be like two people on opposite ends, like at nighttime. But if you're found in an area alone with somebody, it doesn't matter if they came in afterwards and you guys came out later at a different period of time. The fact that you were still seen going into the area, you don't have to be together. They put two and two together, and then they do put you under investigation. You usually do get in trouble. So the fact that there is complaints about this, grievances being wrote, there is videotape surveillance of two of them going to the same place but not going at the same time. But they still just only gave him a 12-hour suspension. And then this constantly comes up over and over again about how he's verbally abusive and that he's had several altercations with prisoners in a sexual manner. And that's why they said it discourages others from reporting misconduct, because the guy that I'm 90% sure I know who this officer is, because there's only one or two officers that actually do the reporting of other officers. They have that code. But it encourages them and makes them not want to do it anymore. There's no point. And it's the same way that these inmates feel at the same time. So no, B, investigations often are inordinately delayed. We identified other serious inadequacies in OIG's investigations practice. Notably, there are significant delays in opening sexual abuse cases after OIG becomes aware of allegations, which place prisoners at risk of continuing serious harm even after they report abuse. The note for that is investigative delays have long been a problem at Lowell. In late 2015, a previous FDOC Inspector General departed under a cloud of criticism that his office delayed or thwarted investigations of suspicious deaths and complaints of abuse. In April 2016, the state announced the appointment of a new Inspector General, who in turn left the position in 2020 and has been replaced by an interim Inspector General. Despite these changes in top personnel and the complaint review process, serious delays persist, as described herein. And about putting off the suspicious deaths, that's something that's always been a problem in Lowell. There's women that do not get the medical care and treatment that they need and are denied medical care. And when they do pass away, it's usually deemed an accident. They don't know what exactly happened. But there could have been so many things that have been prevented, and there could have been care being taken. And there's usually inmates that are complaining, speaking up for these persons. They live with them every day. They know when something's genuinely wrong, and they still get denied. So OIG's Central Intake Unit conducts the first line of review of allegations before complaints are assigned to field offices, where they are then reviewed by OIG inspectors to determine whether a full investigation should be opened. While the centralized intake unit helps relieve the workload in field offices, staffing of the central intake reviewers may not be adequate. There are 6 staff to review all complaints. In the 2016 to 2017 fiscal year, OIG's centralized intake unit received 10,214 total cases, 4,199 and 191 tips line calls from reporting allegations, including sexual abuse and other complaints, a tremendous workload that inevitably results in cursory review of many allegations and causes delay at the first step of the investigative process. We found cases in which delays between an allegation being entered into the system as an incident and receipt by the OIG Lowell Field Office lasted several days or longer, during which prisoners remained vulnerable to alleged abusers. Even once investigations have been referred to OIG, inspectors and are underway, they can be delayed for long periods. Statistics on the outcomes of staff sexual abuse cases in Lowell's PREA corrective action plans indicate that the majority of PREA allegations remain under pending investigation for years on end. In 2017, Lowell had 21 documented allegations of staff sexual misconduct, 16 of which were still in an ongoing investigation as of January 10, 2019. Our review of individual cases timelines also indicates serious delays in investigating cases. For example, on November 14, 2018, an anonymous third party filed a grievance alleging that another Lowell prisoner was having a sexual relationship with a corrections officer who was named in the complaint. The case was assigned for a complaint review on November 16, 2018, but it took 5 months until April 16, 2019 for the alleged victim to be interviewed by an inspector, only for the case to be closed as unfounded at the complaint review stage, based on the alleged victim's denial of the allegations and lack of further interviews or other investigation. The OIG also is under-resourced, leading to high turnover and too few inspectors to adequately investigate the volume of cases. In fiscal year 2017 to 2018, department-wide, 106 investigative staff maintained an average individual caseload of 250 distinct matters. That's a lot. Investigative delays can have serious consequences. Timely and responsive investigatory review process, which Lowell has failed to ensure, is essential to identifying contributing factors to sexual abuse and recommending any changes to policy or practice to help prevent such incidents of abuse in the future. These overly long investigation timelines result in alleged abusers sometimes remaining in close contact with and supervising prisoners, with prisoners at risk of harm on an ongoing basis. Potential witnesses may over time forget details of an incident. Video footage is overwritten after 15 to 30 days and therefore unavailable if a victim does not come forward until several weeks after an alleged incident. Where DNA evidence of sexual abuse may be available, prompt action is critical to avoid spoliation of highly relevant evidence. Moreover, delay in investigating allegations of sexual abuse can directly result in the alleged victim's continued exposure to risk because the alleged perpetrator remains in their position until action is taken. We identified investigations that were inordinately delayed for several years for no apparent reason. Delay sends a message to staff and prisoners that prompt action may not be taken and abuse can continue to occur. So subsection C, record-keeping inaccuracies hinder inadequate investigation. Record-keeping inaccuracies contribute to inadequate investigation systems. We reviewed incomplete case files in which dates and times of interviews were not recorded, or basic paperwork such as case closure notifications to prisoner complainants appear to be missing. OIG tracks and aggregates data on investigations, but these reports contain errors that hinder FDOC's ability to prevent and respond to sexual abuse. One consistent problem is that FDOC fails to track terminations of officers who were dismissed or resigned while under investigation for sexual abuse. Our expert identified reports on dismissals that contained significant inaccuracies. For example, a spreadsheet documenting employee terminations and dismissals from July 15, 2015 through June 2018 did not include an officer who other records confirm was dismissed for cause related to sexual misconduct allegations and other misconduct in 2016. In the spreadsheet we reviewed, a reason for separation was not recorded for approximately 1/3 of the cases listed. The inaccurate tracking system and vague or missing information about terminations mean finding relevant information on abusive officers is difficult. Moreover, FDOC does not track the number of sexual abuse claims against each officer. In an interview with the department in November 2019, Lowell's then warden reported that OIG was responsible for tracking such information, but OIG told the department that it did not track the number of complaints against officers, and did not know whose responsibility it was to do so. Additionally, personnel files on Lowell officers are maintained off-site at another FD's OC location, so records of counseling memoranda, adverse actions taken, or other indicia of sexual abuse complaint prevalence about a particular officer may not be readily accessible through Lowell's official tracking systems. So these systems are just so meaningless. First of all, they're not even stored on the same at the same facility. They are stored off-site and maintained over there, and you can't even reach them. So when an officer does commit a crime and does sexually assault a person, you can't see any of their records. You can't see at all what they've done. So you have officers with lists and lists and lists of grievances on them, but something new comes up and they're treated like this is the first time it's ever happened. And nobody even knows whose side it is, whose responsibility it is to do what, to track how many times these officers are committing these crimes. Nobody knows what they're supposed to be doing. That's genuinely what it seems. 4. Lack of adequate reporting and emotional support systems discourage low prisoners from reporting sexual abuse and accessing needed services. Sexual abuse reporting and emotional support systems are only effective if prisoners are provided with clear, accurate, and uncontradicted information regarding those systems. During our investigation, many prisoners informed us that, for a variety of reasons, they did not trust these systems at Lowell, and that they would not report sexual abuse and harassment allegations or seek outside support services. We identified a number of serious flaws with these systems. A. Lowell failed to provide prisoners with sufficient, timely, and confidential access to PREA reporting hotlines. Prisoners who have been sexually abused require timely and confidential methods to make a report. Such reporting permits the victim to receive protection, obtain medical care, preserve forensic evidence, and obtain victim advocacy services. At Lowell, the window to make timely and confidential reports is extremely narrow and revolves around access to the telephones outside secure living units. Posters in the prisoner living areas list 6 avenues to make a report of sexual abuse. One avenue is to tell any staff member, which would be highly inappropriate if the staff member was the alleged perpetrator. Due to the typical inability of the facility to staff housing units with more than one correctional officer because of a staff shortage, the offending officer may be the only staff person that inmates could report to during officer's shift. Another avenue is to submit a grievance or a prisoner request, which are not designed to address urgent or exigent needs and are also received by a staff member. A third avenue is to report the facility's PREA compliance manager, PCM, which would depend on the PCM schedule and the prisoner's access to her or him. The remaining ways that a prisoner could initiate an urgent report would be to call the external Gulf Coast Children's Advocacy Center line, call the TIPS line, or call a family member, friend, legal counsel, or anyone else outside the facility. If you need a note on that, the Gulf Coast is a certified rape crisis center and has been serving as the FDOC external reporting entity for approximately 2 years. Gulf Coast confidentiality provisions require affirmative signed consent from the prisoner prior to reporting the details of an allegation back to the facility. This would appear to prevent it from being able to immediately forward inmate reports of sexual abuse and sexual harassment to agency officials, as required by the PREA standards. In any event, even if the Gulf Coast was able to meet this requirement, it would be irrelevant so long as prisoners are not informed of the mechanism for prisoners to maintain anonymity when using this option. Separately, prisoners could also write to someone outside the facility, but that would not address an urgent situation. During the weekdays, prisoners are only allowed to use the phones from 5 to 11 p.m. and only in specific locations near the prisoner living unit. And that note, it says with the Lowell Handbook, makes it clear about these rules. The Lowell Handbook is a little, tiny little pamphlet, about 10-15 pages. It tells you about Lowell itself, your rights as an inmate, staff rights, I believe. It does talk about discipline and what happens if you do break the rules, several of them. And it does slightly speak about PREA as well, grievance, and the procedures for those. And the law handbook makes clear that prisoners are prohibited from using any phone except the one in their door. Telephone hours are listed as 5 to 11 p.m. on Monday through Friday. Additional hours are permitted on Saturday and Sunday. The handbook also indicates that prisoners are required to place your name on the telephone list and are only to make calls during that time period. Investigative staff informed us that telephones are disconnected outside of the designated hours. But for prisoners relying on the phone system, this could create a delay of several hours after the time of victimization. For serious incidents of sexual abuse, such delays in reporting potentially place victims in grave danger and may compromise the investigative process. Lowell fails to provide prisoners with clear information regarding avenues to report sexual abuse to an external entity, instructions on maintaining anonymity if desired, and access to outside confidential support services. Prisoners who have experienced sexual abuse may not trust internal reporting mechanisms and may feel that agency or facility personnel will ignore or cover up an allegation, or may feel fear retaliation for reporting to agency staff, justifiably. Similarly, prisoner victims seeking confidential emotional support services know that providing information to facility mental health providers will result in a formal report of victimization, raising identical fears of cover-up and retaliation by staff. So they're pretty much put in a corner and trapped. They don't know what they can do, what to do, because there's fear of retaliation from every side. Accordingly, PREA requires agencies to provide both an effective external reporting mechanism and effective and confidential access to an external entity for emotional support services. The note on that states that the standards 28 CFR 11551B, 11553A, these standards are sometimes conflated, but represent two distinct requirements in the standards and serve entirely different purposes. Prisoner education materials regarding anonymous external reporting and access to outside confidential emotional support services for Lowell prisoners is, on the whole, incomprehensible. Every measure that they have taken is remedial. And even just like they mentioned the cameras, yes, they put a few up here and there, but not in the places that the sexual activity is known to take place. They just brush it right off their shoulders and sweep it right under the rug. Every measure that they up here and there, but not in the places that the sexual activity is known to take place. They just brush it right off their shoulders and sweep it right under the rug. And this is the Department of Justice here telling us that every measure that they are taking, it's incomprehensible how little anything is successful. So we identified incomplete, inaccurate, and contradictory information about prisoner reporting, anonymity, and outside confidential support services among the various prisoner and staff educational material we were provided. These materials included the RCP Handbook, the Lowell Handbook, educational posters within housing units, the FDOC PREA Guide, the PREA Education Facilitators Guide, and the Sexual Abuse Awareness Pamphlet. Conflicting information about the nature of the anonymous external reporting mechanism and avenues to access confidential support services not only creates distrust among prisoners, but also confuses staff and increases the potential for staff to further misinform prisoners. In fact, Lowell's external reporting entity, Gulf Coast, has received only about 6 calls. 6. In the 2 years it has been serving as a reporting entity, a number certainly incongruous with the prevalence of prisoner allegations at the facility. Prisoners are unlikely to engage in access to needed outside emotional support services if they believe that such communications will be monitored or recorded by facility personnel. So C. Officials at Lowell knew of the risk to prisoners from staff sexual abuse and disregarded it. Officials at FDOC and Lowell have been on notice of incidents of staff sexual abuse of prisoners for years and have failed to reasonably address the deficiencies that enable the abuse to occur. By disregarding the obvious risk to prisoner safety, officials at Lowell evinced a deliberate indifference to prisoners' constitutional rights that enables staff sexual abuse of prisoners to continue. While the department's investigation focused on credible allegations of officers sexually abusing prisoners from 2017 to 2019, many of which resulted in findings of wrongdoing, officer arrest, and/or criminal charges, the problems are long-standing and FDOC officials have been aware of a pattern of sexual abuse for years. In December of 2015, a series of Miami Herald articles focused on Lowell and reported widespread abuse of women prisoners. The articles discussed conditions at Lowell dating as far back as 2005. The series uncovered numerous incidents of sexual abuse and harassment by FDOC staff on prisoners based on interviews of Lowell prisoners, both current and former, and a review of misconduct reports filed against FDOC officials at Lowell, personnel files, prisoner histories, criminal records, as well as investigative reports. Prior to the publication of the series, FDOC released a statement acknowledging that FDOC worked with the Miami Herald in providing thousands of public records and answering hundreds of inquiries regarding its facilities. Included in the statement was a comment from then Secretary Julie Jones, who acknowledged that prior to her taking over in January 2015, Lowell was a poorly managed place and lacked the leadership necessary to properly operate a correctional institution. Publication of the Miami Herald series put FDOC and Lowell on notice of the risk to prisoners from staff sexual misconduct, and the state responded by approving funding for capital improvements, including increased camera coverage, appointing a new warden at Lowell, reporting staff firings or disciplinary actions at Lowell, and requiring review procedures when prisoners were placed into confinement after making claims of sexual misconduct. And let me just say that they gave them the money to increase camera coverage, but they still haven't put it in the mezzanines that they know that staff abuse prisoners. However, these piecemeal measures were not reasonable steps to meet FDOC's constitutional obligation to protect women at Lowell from sexual abuse by staff. Significantly, no reasonable steps have been taken to address long-standing staffing inadequacies regarding security or investigative staff, nor have specific remedial measures been reasonable. For example, while additional cameras may have been added from time to time, they have not put any in the mezzanine areas, like I just said. Further, despite the installation of a new warden following the Miami Herald article, systemic deficiencies in protecting prisoners from sexual abuse continue to place prisoners at risk of harm. Lowell prisoners remain at risk of serious harm from staff sexual abuse, and FDOC has not taken reasonable efforts to address this risk. And this has been going on for 10 years. I have a PREA audit from 2009 to 11 that I'll put a picture of. And in there, it states that there's over 300 staff on inmate reported cases of sexual abuse, and only 4 of them were substantiated. And where you may just go into the mind thinking of it, well, that means staff are doing a good job. No, the Department of Justice has clearly indicated by this investigative finding that the people at Lowell, they don't do their investigations either. They don't complete them. They let people go instead of holding them accountable. There's nothing that actually ensures these women any safety and lack of retaliation and any fear of consequence just for trying to stand up for themselves. So in addition, officials at FDOC and Lowell are aware of dozens of incidents dating back to 2013 in which Lowell officers were alleged to have engaged in sexual misconduct with prisoners, but failed to take action to address the systemic issues with sexual abuse at Lowell. In 2017, problems with the risk of harm to prisoners from staff sexual abuse and the disregard of this risk persisted. For example, in March 2017, the warden sent an email addressing an officer at Lowell who at the time had multiple allegations against him, with many of them being sexual in nature, according to that email. At that time, of the 10 investigations against the officer, 6 remained open. While this officer was ultimately relocated to another facility, it took 10 allegations, including allegations involving sexual misconduct, before action was taken against the officer. Yet in November 2019, when the department asked who was responsible for tracking the number of PREA allegations against a staff member to identify potential issues with staff misconduct, an OIG inspector told us that there was no such system in place. None. In our review of Lowell investigatory files, we saw no evidence of reasonable corrective action by Lowell, even though instances of sexual abuse continue to occur along repeated factual patterns, and they run rampant in that prison. In particular, OIG has put Lowell officials on notice of Lowell's delinquent or non-existent response to allegations of sexual abuse. For example, in December 2017, while notifying officials at Lowell of outstanding PREA allegations in which no action had been taken in response, OIG noted that this has become a constant issue. In October 2017, an OIG inspector notified the Lowell warden and a colonel that a PREA number had not been generated, meaning that a report had not been put into the system, and post-rape guidelines had not been followed for a prisoner's allegation that a staff member had raped her. The OIG inspector noted that he had not received a sexual misconduct incident report or prisoner statement, even though the prisoner had made a serious PREA allegation against a staff member. The report had initially been handled as only a use of force allegation, even though it contained PREA allegations, resulting in unjustified delay in handling an urgent PREA matter. OIG's Emergency Action Center, EAC, which receives emergency complaints, also had not been made aware of the rape allegation, according to the OIG email, despite the allegation being reported. In late November 2017, OIG notified top officials at Lowell that a prisoner called the tips line in October 2017 and again in early November 2017 to report sexual abuse, but as of late November 2017, nothing had been done by the facility with regard to the allegations. And that's not even just saying nothing to correct it. Nothing was done to even investigate it. Nobody was talked to. It was literally just moved away. What's out of sight is out of mind. And if they can keep it out of closed doors, more power to them. That's what they think. And just imagine being a woman that's just been sexually assaulted like that, and you're in such a state of dismay and distress, and you think you have a resource provided to you from the prison that helps prevent this, and then the Emergency Action Center isn't even made aware. And you can see that there's multiple people that have dropped the ball, and it doesn't seem that the prison itself cares for the safety and the well-being of these ladies. Lowell did receive a successful PREA audit in 2019. However, a passing PREA audit does not ensure that a facility is constitutionally compliant. The PREA final rule makes clear the standards are not intended to define the contours of constitutionally required conditions of confinement. Accordingly, compliance with the standards does not establish a safe harbor with regard to otherwise constitutionally deficient conditions involving inmate sexual abuse. In addition, while Lowell took some measures to address deficiencies raised by the PREA audits, Lowell's severe staffing deficiencies discussed above remain unremedied, despite the notice provided by the 2016 PREA audit and additional reports noting the serious risk to prisoners posed by Lowell's understaffing. These notes are really important, I gotta let you know. The Lowell's 2016 PREA audit report, issued on or about November 4th, 2016, identified two areas of PREA noncompliance. The auditor issuing this report was decertified by the department on February 14th, 2019, for failure to comply with the PREA audit methodology requirements. The second final PREA report was issued July 8th, 2019. Here you go. The auditor issuing the 2019 report remains certified by the department. This audit was contracted through an entity known as PREA Auditors of America, LLC, PAA. Public records indicate that PAA is the recipient of a contract for the Bureau of Prisons and also maintain contractual relationships for PREA audits with the U.S. Air Force and the U.S. Navy. And the PAA leadership team includes this middle part isn't really relevant. So the PAA leadership team includes a named president and vice president. Neither of these leadership team members are certified by the department to conduct PREA audits. Nevertheless, the vice president's description on the PAA website says, with over 35 years of detentions experience, the vice president sets the standards and leads the auditing team for PAOA, emphasis added. Let me just redo that for you. The vice president is the person who is not certified, but he's also the person leading these PREA audits. This isn't just like regular auditing paperwork and you're going to get fined. No, this is people's lives. You're auditing people, sexual abuse encounters. This is really important statistics that need to be monitored, and they're not even being filed. So on January 10th, 2019, an assistant warden acknowledged in an email to the warden at the time and another assistant warden that Lowell's 2018 PREA corrective action plan showed that Lowell doubled the number of PREA allegations from last year. The assistant warden further stated, "I did my best to make the increase in PREA cases sound like not such a bad thing." In November 2019, the department asked the former warden, current warden, and an OIG supervisor what steps had been taken to increase the PREA allegations from 2018. No one could speak as to any steps that had taken to address the issue since the 2018 report came out. It's literally so out of sight, out of mind. As long as they could sweep things under the rug and try to let people not focus on it, they're going to keep letting people get away with this. It's not a big enough deal to them. It's been happening for 10 years, and you can see when confronted with the evidence, the people just try to make it look better, make it not sound as bad, try to not make rape, choking, sodomy, all of these things not sound as bad as it truly is for the women that are already incarcerated and serving their time. And in the year that the PREA reports had doubled, nobody cared. Nobody even stood to address it. So to wrap it up, we're talking of the minimal remedial measures. These are the recommendations that are coming from the Department of Justice to be placed into Lowell Correctional Institution. As the efforts by FTOC to address the issues outlined in this notice have been thus far inadequate to protect women from sexual abuse at Lowell, the following remedial measures are necessary. Comply with PREA and its implementing regulations, the national standards to prevent, detect, and respond to prison rape. If it is necessary to hold prisoners who report sexual abuse in administrative confinement or other segregated housing in order to keep them safe from further abuse or retaliation, ensure that such prisoners have access to privileges including telephones, visitation, commissary, programming, vocational opportunities, and outside recreation. Nope, I was not able to get my cosmetology degree because I was under investigation and administrative confinement, not for a PREA thing, but it makes it so hard to actually want to do right when you get things taken away for doing such little things or standing up for yourself. So they recommend to ensure that prisoners have internal and external confidential options for timely reporting sexual abuse and sexual harassment anonymously if requested, including an option that is independent from FDOC. That's a long shot. Ensure that prisoners receive accurate and complete information and education on how to access all internal and external confidential reporting options. Ensure that prisoners who report sexual abuse have access to victim advocates during evidence collection and investigative interviews. Ensure that all prisoners have access to confidential external emotional support services related to sexual abuse. Develop and implement a system for monitoring retaliation consistent with the PREA standards to ensure that persons who report sexual abuse or sexual harassment do not experience retaliation by prisoners or other staff. Yes. Develop and implement a new staffing plan, taking into account all the factors delineated in 28 CFR Standard 115.13a in order to ensure adequate staffing levels and, where applicable, real-time video monitoring to protect prisoners from sexual abuse. Complete and implement the plan for strategic placement of additional cameras at Lowell with appropriate oversight and review of camera footage. Cameras and video maintenance systems installed should have the capability of retaining video data for not less than 90 days. Yeah, instead of they said 15 to 30 days. And capacity to store selected video indefinitely. That would be great. Ensure that access to and from the Lowell compound is through secure checkpoints only. They try. Ensure that anyone entering the Lowell compound, including staff, undergoes appropriate contraband screening. There you go. Ensure that all OIG and Lowell PREA investigators and administrators receive specialized training in sexual abuse investigations. Specialized training shall include techniques for interviewing sexual abuse victims, proper use of Miranda versus Arizona, and Garrity versus New Jersey cases, warnings, sexual abuse, evidence collection in confinement settings, and the criteria and evidence required to substantiate a case for administrative action or prosecution referral. Ensure that Lowell's warden has access to investigative files and regular briefings of PREA investigations that include sufficient details so that the facility warden and/or the incident review team has sufficient information to devise and implement any necessary movement, discipline, or corrective action. Also, my personal opinion, I recommending letting the OIG or someone assigning a position to monitor the previous instances of staff abuse history that they said was not ever done. So with all these together, they will hopefully be able to make some form of a difference. So to finalize this 36-page investigation, which is actually 34 pages, The department has reasonable cause to believe that Lowell violates the constitutional rights of prisoners in its care, resulting in serious harm and the substantial risk of serious harm. Specifically, Lowell fails to protect women prisoners from harm due to sexual abuse by staff. Finally, as explained above, the department has reasonable cause to believe that Lowell's violations are pursuant to a pattern or practice of resistance to the full enjoyment of rights protected by the Eighth Amendment. We look forward to working cooperatively with the state of Florida to ensure that these violations are remedied. We are obligated to advise you that 49 days after issuance of this letter, the Attorney General may initiate a lawsuit pursuant to PREA to correct deficiencies identified in this letter if state officials have not satisfactorily addressed our concerns. Please also note that this notice is a public document. It will be posted in the Civil Rights Division's website, which is where I found it. Now, it's easy to tell that it's most likely nothing's been done. It's been a year since the last instance from 2018 to 2019, where the statistics had doubled in the reportings. And they only have 49 days for them to fix all of these problems, including the investigative teams and the completion of investigations, training, monitoring, and cameras. And it's doubtful that they're going to even want to do that, let alone try. And a lawsuit is going to most likely just be paid off. The amount of money that there's going to have to put into this to fix it is substantial. And it is my job to actually sit here and take the time to read you all 34 pages of this, because you can see how many of the efforts are made to just brush it off and act like nothing ever happened. And this might be your family member. This might be somebody that you love that's sitting in there dealing with this, and they don't have the ability to tell you. And every time they try to tell you, it gets stifled. They're being so much more stricter on phone calls, on visitations, on writing, on being able to even put money on someone's account. You have to be on their visitations list. They're making it so hard for someone to be an individual and just trying to make them so much into a number. You lose your identity. And it makes it so hard for someone to come back out and actually try to be rehabilitated. So if we actually take the time to address these concerns and make a difference and actually hold these officers accountable, not only will there be a difference inside of our prisons, but those officers that are going to continue that behavior on the outside won't be able to, because they will be held accountable. And that's the beginning. I think we just have to start holding people accountable, start doing investigations properly. And I hope you've enjoyed all of this so far. I had to record at work. Thank you for staying tuned for all 4 of these videos. Please, please, please like and subscribe. I'd really like to speak out for my girls. And if you know anything you'd like to share, please let me know. Message me, comment me, formidable_felon on Instagram. Let me know. I'd love to have you be a part.